A young advocate who is also a subscriber on our channel Legal Inspiration wants to know what is the difference between a written statement and an affidavit in reply. I'm sure although this question is asked by that young lawyer only, still this may be useful for other young advocates also. So I have chosen this question for answering in the video. By the way, the name of that young lawyer is Manisha Deshmukh, and I thank her for asking that question. Friends, this video is going to be in English, and I have seen many requests on my channel for making videos in English. So what I have decided is that from now onwards, from this video onwards, whatever video that I make for young advocates or law students will be in English, and the videos that I make for others, for general people, will either be in English or maybe in Hindi, or maybe the mixture of Hindi, English, or maybe in Marathi, depending upon the situation. Okay, so having said that, let us move ahead with the topic of today's video. What is the difference between a written statement and an affidavit in reply? So before we get into the details of the differences between a written statement and an affidavit in reply, let us understand what is common about it. A written statement or an affidavit in reply both are responses to something. They are replies to something. So that's the common factor. But then what are the differences? Now coming to the differences. Certainly there are many differences in them. The fundamental difference is that a written statement is filed in trial court in response to a plaint in a civil suit, whereas an affidavit in reply is filed in High Court in response to a writ petition. You got it? A written statement is a pleading in the trial court, and an affidavit in reply is a pleading in the High Court. A written statement is filed in response to plaint in a civil suit, and an affidavit in reply is filed in response to a writ petition in High Court. Of course, it can also be filed in those courts wherever there is such practice of deciding cases on the basis of documents only, without actually taking evidence. When you draft a written statement, you have to strictly follow the rules of pleadings, the 4 basic rules of pleadings that I have explained in other videos. What are those rules? I will quickly sum up. You have to plead facts and not law. You have to plead material facts only. You have to plead facts and not evidence. And then you have to be precise, concise, and accurate. These are the 4 fundamental rules of drafting. They apply to drafting of a written statement with full rigor. And that's how a written statement is to be drafted. The reason for that is that the facts stated in the written statement are not taken by the court as true on their face value unless the defendant enters the witness box and proves those facts. So there has to be a proving procedure later on. So written statement is the foundation of the evidence that would be laid by the defendant, just as plaint is the foundation of evidence that would be laid by the plaintiff. Right? Clear up to this? Okay. Now let's move on to an affidavit in reply. An affidavit in reply, of course, is also to be drafted in accordance with the rules of pleadings, but here the rules of pleading get liberal, in the sense that when you draft an affidavit in reply, you of course have to plead the facts and the material facts. But the liberty is in also pleading law. And you can also plead evidence in an affidavit in reply. Just as in a writ petition. Writ petition is a combination of three things normally, like it's a combination of facts, arguments, evidence, and law. It's a mixture of that. That's why it's called a petition. In a similar fashion, a response to a writ petition is also drafted. That is affidavit in reply. A person swearing an affidavit in reply states the things stated in the affidavit in reply on oath before the High Court. And the High Court, while considering affidavit in reply, takes the statements made in that affidavit in reply as true on their face value. Of course, these statements, if disputed by the other side, are not to be taken as true. As I told you in a video regarding writ petitions are decided only on the basis of affidavits filed before the court. The High Court does not take evidence separately. Whatever evidence is there available with the parties has to be produced along with the writ petition before the High Court, or if he is a respondent, he has to produce that evidence along with the affidavit in reply before the High Court. So a writ petition is decided on the basis of the documents or the facts which are undisputed, which are not disputed before the High Court. If any fact which is material is disputed in a writ petition, High Court would simply not entertain the writ petition and would relegate the parties to have their claims decided in a civil court, because it is the civil court which can take evidence by asking the parties to enter the witness box and by asking the other side to cross-examine the witnesses. These things are not there in a writ petition before the High Court. So, coming back to our main topic, this is the reason an affidavit in reply is much liberal than a written statement. A written statement has to strictly follow the rules of drafting, whereas an affidavit in reply can be more liberal.